On
Good. He's given an outline of his case. His first case is that suppose my prayer on specific performance fails, I'm still entitled to refund and
let them submit. Let
damages.
them finish. We will come with a reply.
I can give it first point. I can
Definitely.
answer right now.
Let it not be piecemeal because Mr. Ghosh has not completed his submissions.
On prayer of the learned counsel for the plaintiff, further argument is adjourned to
But this week, anytime, my lord, because
This
there is
week
no,
some
not
reason.
not this week.
Because why they want to delay, there is some reason.
11th April.
Grateful, Lordship.
Lordship, little accommodation, lordship can be
Earlier or later on?
earlier.
10th.
Would you be able to get it?
Lordship, I will get it in this week. So any day next week, Your Lordship.
9th April.
Lordship,
Grateful.
deeply obliged. 9th April, ওই ম্যাটারটা
28 and 29.
They want the other matter to go on. That's why they are prolonging this matter.
Yes.
My lord, I was arguing. Don't see Mr. Lahiri.
Where is Mr. Laidi? His junior is not here.
Client was here. No, before the other day, my lord, on last occasion, one judgment which my lord had, it fell from my lord, that Park Street properties. My lord, I was looking through it.
Very possibly that defense will not succeed. That point will not succeed. Tenancy issue.
No, my lord, it might. Because there, in Park Street properties, the dispute was not whether it's a license or a tenancy. Both parties agreed that it was an unregistered lease. 30
I will
years.
check these judgments.
My lord, I have, my lord. I intended to place it, my lord. My lord takes paragraph 2 and 3 first. Well, this is 2016, volume 9, SCC 268. My paragraph 2 and 3 sets out the case. What was in issue was whether the 15 days notice that was given was sufficient. Parties were at paragraph 2, my lord, it was a 30 years lease at a monthly rent of 20,000 per month. So tenancy under the Rent Act was not in contemplation. What was argued was, that will appear from paragraph 17, 18 and 19, that the lease was for 30 years, therefore it was a year-to-year lease, and hence
Paragraph
17, 18 and 19. May I read out, my lord? A perusal of section 106 makes it clear that it creates a deemed monthly tenancy in those cases where there is no express contract to the contrary. Pausing here for a moment, my lord, we have a contract to the contrary, which is terminable at a notice period of 15 days. The section also lays down requirements of a valid notice to terminate the tenancy, such as it must be in writing, signed by person sending it and duly received. Admittedly, the validity of the notice itself is not under challenge. The main contention advanced on behalf of the respondent is that the judgment on order is valid in light of section 107 of the Act, which requires that a lease for a term exceeding 1 year can only be made by a registered instrument. Thus, in clause 6 of the agreement, the landlord was entitled to terminate the lease in case there was a breach of terms. My lord, and the remedy of the same within a period of 30 days from the receipt of the notice. The above clause, there was a clause in the agreement which was set out, the default clause. The above clause is clearly contrary to the provisions of section 106. While section 106 of the Act does not contain the phrase in absence of contract to the contrary, it is well settled position of law as set out, pointed out by learned senior counsel appearing on behalf of that there must
Mr.
be.
Lahiri, have you seen this judgment?
I don't think so. Yeah, that's it. 16. So, my lord, then my lord 20. This clause, this default clause, clause 6 of that agreement was then considered to be contrary to section 106. Clause 20, my lord, somewhere in the middle, the terms of the same cannot be used to derogate from the statutory provision of section 106, which creates a fiction of tenancy in absence of a registered instrument creating the same. If the argument advanced on behalf of the respondent is taken to its logical conclusion, the lease can never be terminated, save in breaches by the tenant. Accepting this argument would mean that in a situation where the tenant does not default on rent of payment for 3 consecutive months and does not commit a breach of the terms of the lease, it is not open to the lessor to terminate a lease even after giving a notice. This interpretation of clause 6 of the agreement cannot be permitted, as the same is wholly contrary to the express provision of law. The phrase contract to the contrary section 106 cannot be read to mean the parties are free to contract out of express provisions of law. That was the issue. It was not the issue as in the judgment which I was showing, 77 Supreme Court cases, that if there is a void lease, then it will automatically mean there is a tenancy. Having said so, my lord, may I only take my lord through his written statement to my suit?
Come with your notes of argument.
I will.
Speech this one with your notes of argument.
Yes, I will, my lord.
Compilation of judgment.
I apologize, my lord. It's still a work in progress.
Good.
I will.
Written statement.
Yes, my lord. That would be in that compilation at page
28.
Page 28, my lord.
Yes.
I shall rely on paragraphs 2, 8, and 30.
2,
8, and 30.
In written statement? No.
My lord, the written statement is at page 14, my lord. I think so. 14 or 15, my lord. The what is there in page 28 is the additional written statement after the amendment was allowed. Page 14, my lord, the written statement starts at page 15, my lord, of the compilation. Paragraph 2, my lord.
Mr. Lahiri, what does it mean?
Bad for non-joinder and misjoinder of parties, although there was a written agreement with
written argument.
All written must be a misprint. Although there was a written agreement is between plaintiff and defendant, but the agreement upon as the
What
tenancy
does it mean?
agreement, or the agreement is a tenancy agreement. My lord, sometimes, my lord, we are also at fault. We miss out the typographical errors. So, my lord, their case is that it's a tenancy agreement. Second, my lord.
Again, para 4, there is no specific court of action.
Cause of action, my lord. Court action to initiate. Right, I don't think Mr. Lahiri was there at the point of time. He came after.
You are saved. He is saving you.
No, my lord, we have to be fair. Paragraph 8, my lord. It is a fact that the defendant entered into possession on 1st April, also deposited a sum of rupees to 2,70,000 as interest-free deposit, and the plaintiff herein license fee.
No, the agreement is admitted.
and herein the agreement is admitted. See, they also in their plaint also, I have shown my lord their plaint, paragraph 3 and 4 and 7 of their plaint. The agreement is admitted. He says it's a tenancy. My lord, why I am showing my lord this written statement in paragraph 13, my lord, where he deals with the notice which I had given on 5th of March 2009. Statement made in paragraph 7 and 8 of the plaint are partly admitted and partly denied by the defendant herein. The defendant states that his learned advocate, Supriya Ranjan Saha, issued a notice to the plaintiff dated 5th March 2009, stating inter alia that the agreement is a tenancy agreement, not leave-in license, and file a suit for declaration of tenancy rights.
So there is an agreement,
There is an agreement. They say
but the nature of agreement is in dispute.
the nature of agreement is in dispute. I say that
It is a leave-in license, and
the
their
le-
contention it's a
is a
tenancy.
leave-in license agreement. They say it's a tenancy. Now, what I'm trying to show, my lord, from their written statement is that their case that they have now tried to make out in argument that no, I'm claiming a tenancy under section 106 of the Transfer of Property Act is nowhere pleaded. And my lord will kindly take the order dated 21st June 2016, where the issues were framed.
Now come to the pleading, written statement.
Yes, my lord. Declaration. The defendant also files a suit for declaration, obtain injunction, speaks of it. Then my lord goes on making denial of my case. There is no positive case made out.
No, that cannot be said, because when he's asserting that the agreement is a tenancy agreement, that is their positive case.
Their positive case is that it's a tenancy agreement, and I have shown my lord the appeal court's order.
Where is the order?
That order, my lord, is, I think, part of the judge's brief of document. Justice Kollanjyoti Sengupta's order I had shown, my lord, recording their statement that they are premises monthly tenants under the Premises Tenancy Act, and that is where, my lord, might kindly come to page 119 once of the
91.
119 of this compilation. What is the issue framed?
Maintainable agreement.
Comes to issue number 3.
Premises Tenancy Act, possibly not, because the rent is much lower, much higher.
Yes, well, but their case was this. Entire case, their case, they nowhere say in their plaint or in the written statement that I am a tenant under the Transfer of Property Act under section 100, as contemplated under section 106. Nowhere do they say this. Issues are framed. They file an appeal before that in 2010 or 11, I think the appeal was filed.
Against issues.
We obtained a decree under chapter 13A. And my lord will also consider this. Once I say I am a lessee under first of all, section 106 does not use the word tenant. It says lease, month to month lease. And it will be terminable by 15 days notice. Section 107 says in subparagraph 1 that a lease for a term exceeding 1 year has to be by a registered deed. Then in subparagraph 2 it says any other lease can be executed in any other manner. So assuming that the document of Exhibit D, the document of 1st April 2009 was a lease deed, lease for month to month, then what are the defense left? Practically defenseless. Barring validity of the notice, Possibly there is no other defense. Unlike a tenancy under the Rent Act, that is the difference between a tenancy under or a lease, month-to-month lease under the Transfer Property Act and a monthly tenancy under the Premises Tenancy Act. The rigors are much more. And my lord, I have shown, I had placed judgments, even judgments which they had cited, which says that while interpreting a document as to whether it creates a license or a lease, the prime consideration is whether the document was
Intention.
was it worded in such a manner to camouflage, to avoid the rigors of
Tenancy in masquerade.
masquerade license, rather to avoid the rigors of the Rent Acts. Because a Rent Act under Section 13 of the 1956 Act or under Section 6 of the present Act, there are specific grounds on which even a court of law can evict a person. And the notice is the notice of a suit, as held in AIR 64 Calcutta 1. It's not a notice terminating the statutory tenancy also. But in case of even a lease, month-to-month lease under Section 106, it is terminable by a month,
15 days
15 days
notice.
notice. So basically defenseless. So when I am against a proceeding for eviction, seeking to create a defense, it has to be, I have to take it towards the Rent Act. And issue is framed. There is nothing in their written statement or in their plaint which even suggests remotely that it's a month-to-month lease. Even if it is a month-to-month lease, it is terminable under 15 days notice, and Exhibit F is my notice. I have given a notice. I didn't intend it to be a notice under Section 106, because my case always had been, even in the in the examination of chief of my witness and in the cross-examination, the undemolished case is that we inducted him as a licensee. I have shown, my lord, the entire deed. There are specific provisions in that deed which agitates against him claiming even exclusive possession or claiming any right other than what is being given, what is written there. And my lord, I have shown, my lord, the judgments which says even getting exclusive possession is not a sine qua non of tenancy or even a month-to-month lease. That is why, and I also shown 1977 volume 3, I think, Supreme Court cases. Just a minute. 4, no?
Mr. Ganguly, do one thing. Come with a compilation of
Yes,
judgments.
but I
with your
will
notes.
finish in 2 minutes, and then I'll come with compilation of judgment, and on the next day I'll start on the second point. This was 19.
All compilation of judgment should be there so that I can make mark
Absolutely. Right.
relevant portions.
1977 volume 4 Supreme Court cases, I think 324, Technician Studio, where it says, my lord, in paragraph 4, that a lease which, assuming that document is argued to be a lease document, assuming that such a document which violates Section 107(1) is a void document. And it is not in every case that a void document will give rise to the presumption of a month-to-month lease under Section 106. And here, my lord, Section 106 clearly says subject to a contract to the contrary. Now, I did not give, my intention was never to create a tenancy or a lease. Even at that point of time, he was happy to get the license. He was happy to get in. With full knowledge of what he is doing, he got into that document. Without, as his own evidence is, without finding out who is giving him, without finding out what is the nature of the person's authority to give. That is his evidence. I shall, my lord, in the second issue, I'll show those answers. He enters into that. Now, when it is time to leave, he raises the bogey of tenancy. Now, assuming that my lord comes to the conclusion that very well a month-to-month lease can be interpreted, then also I have given him a notice. The notice was dated 25th February 2009.
Case of expiry, no notice is needed.
One is his own case that I was given a tenancy for 5 years. So automatically expiry, no notice is needed. Now, assuming that is not the case, it's a month-to-month lease. And 111 is A of the Transfer Property Act does not apply.
One issue is whether there is a monthly tenancy divorce of this agreement. Other is whether this agreement should be interpreted as a tenancy agreement
Or a lease.
and the tenancy
or a license.
subsisted during this tenure of the tenancy.
It did not.
Two issues are there.
That is where I'm coming, my lord. On 25th of February 2009, which is Exhibit F, I give him a notice which he receives that leave after 31st March 2009. Now, in my respectful submission, assuming it is considered that...
But here it is accepted by both the parties that there is a subsisting agreement.
Yes.
Now, if the subsisting agreement is there, then the tenancy, whether in nature, what may be the nature? It may be a tenancy, it may be a live-in license or tenancy in masquerade, whatever and whatever way you may interpret it, this agreement, when expired, put an end to the tenancy.
Yes.
This is an accepted position.
And
once you are accepting, it's an
and
agreement.
In addition, I have told him on 25th February 2009.
And that notice is an abundant precaution.
Abundant precaution. I have told him, see, there was a license agreement with you. It expires on 31st March 2009. Kindly leave. I am not going to, there's not going to be any renewal whatsoever. And before that, he filed a suit in 2008. When I stopped taking the rent, I was adjusting the security deposit. So, my lord, in my respectful submission, given the position in law now, that any relationship between two persons in respect of where a person is put into possession, which attracts a rent in excess of rupees 10,000, 45,000 in this case, tenancy does not apply, rent tax does not apply. Most of the judgments which are shown on exclusive possession or on how to interpret such a document are on the basis and for a period where the old act was in effect. 56 Act was in effect, and the consideration in law was completely different. Section 3F of the earlier act and Section 3F of the present act, rent act, is completely different. The agreement which both parties admit to have entered into says it's a license agreement. It has clauses which restricts the right of user to a certain purpose. It provides that the exclusive possession is not given. You may have been put into possession, but don't consider this is exclusive. That is there. So it cannot be anything other than a license agreement. And it has come to an end. Even otherwise, parties agree that there was a agreement. If it is considered that under Section 106 there is a month-to-month lease, then also I have issued a notice, which is given him more than 15 days actually. I had given him about 1 month and 5 days notice.
All right, come on the next date, 9th April.
No, my lord, can it be after 20th?
I want to close it up.
I want to close it up also, my lord. But, I will not be available next week.
22nd?
22nd.
Hard in part, adjourned to 20, because this, this suit is not within my determination possibly. Yes.
No, but it's parted, my lord. My lord.
That's why it is coming.
Yes, yes.
Mr. Laidu would have been happy.
No.
Anyway.
No, my lord. No, none. I don't think councils become happy. Because the effort...
Mr. Lahiri would have been happy.
Because if I am speaking for him also. because the efforts are to be renewed. And I have always seen when you are arguing the same matter again, you miss out.
Lose the steam.
You lose the steam, you miss out a lot of things.
Absolutely.
But only one thing.
Because certain things evolve in course of argument. Certain thoughts evolve in course of
Yes, my
argument. And that is also because of interaction with the court.
like the judgment I had shown, my lord.
There is
But,
another judgment, you check it, Jabalpur municipality.
I have, my lord, that I have also gone through, but I don't think
That is very relevant.
it will be relevant. And particularly Park Street properties, I say that the consideration was completely different. Parties agreed that it was a lease. Parties agreed. No. ওই সে সেদিন বললো না না জাস্ট ওই কিছু ডকুমেন্ট জমা পড়েছিল. These are exhibited. Just made up. I saw there was a supplementary judges before document created. May I? These are also exhibitors. All are exhibitors.
Hard in part, we adjourn to 22nd April.
ওটা লিখে রাখবেন সাপ্লিমেন্টারি item 30.
Well, this is my application for grant of probate, my lords. Well, the citation has been issued. Thereafter, though the citation could not serve, then the publication has been made.
After execution of the will for till the date, never this propounder visited the testatrix.
That's after propounder. That is.
And I asked this question.
Your lordship has asked these questions and he has answered that yes, they have. But so far as the in regard to
evidence
prove that will, the person has filed the attesting witness.
Who is the attesting witness?
My lord, there's a two attesting witness.
Taruknath Dotto.
No, Tarangnath Dotto is the attending witness.
Who is the attesting witness?
Attesting witness, one is Subroto Sengupta and one is some Bhattacharya. So, affidavit of attesting witness has been filed by Atanu Bhattacharya. So, my lord, by filing this affidavit, one of the
Just a minute.
affidavit of attesting witness.
What is the name you said?
Atanu Bhattacharya. Atanu Bhattacharya. He is the second witness of the will. Affidavit হবে সবুজ কাগজ হবে আগে
Do one thing, let it come tomorrow. You find it out. Not today. Only not today. Not now. Not now. Come after court hours.
My lord.
Item 31.
Query for the plaintiff in this matter. My lord, the
Witness action is there?
my lord, I'm appearing
Witness
for
is there?
witnesses here, my lord.
Ex parte?
No, my lord. The judge's brief has already been filed in the matter.
Issues are framed?
Already issues were framed.
Let me
Yes,
see the issues.
3rd of April 2024. The issues were framed.
मैं इस मुकदमे में जो कुछ बोलूंगी सच बोलूंगी, सच के सिवाय झूठ नहीं बोलूंगी, कुछ नहीं छुपाऊंगी। भव्य भव्य बोथरा, AVYA, BAVBHAVYA,
এটা নিয়ে না
जी बोथरा।
এটাকে সরিয়ে দেবে ক্রিমিনাল গুলো
हस्बैंड का नाम है शैलेश बोथरा, SHAILESH, शैलेश चंद बोथरा मिडिल नेम है।
My lord, I will proceed today, and then my
52.
lord, we shall keep it after some time. And my lord, at that stage, I would be seeking for consecutive dates because my lord, the witness is traveling from Bombay.
Residential.
Don't look at him.
Okay. 9A, Great Eastern Royal Building, ताड़देव, मुंबई। ताड़देव, TAR, DEO, देव, मुंबई, 34।
Witness, are you in a position to indicate why you are before this court today?
जी, इधर मैंने कोलकाता में सुधा काकरिया को लोन पे रुपए दिए थे और उन्होंने मेरे से प्रॉमिस किया था जब मैं मांगूंगी 3 महीने में दे देंगी।
Slowly.
3 महीने का।
Wait, he will translate.
I had given some money to Calcutta,
जी,
residing in
कल
Calcutta, and she had promised me that I had given some money to Sudha.
I lent money to Sudha Kankaria, the defendant.
pay.
नो शी विल रीपे इन 3। मैं 3 महीने में उनसे मांगूंगी तो 3 महीने का टाइम लेके वो मुझे दे देंगी।
Pay the money.
नो
Within 3 months time from demand.
हाँ,
Much of that. How do you know Sudha Kankaria, defendant in the proceedings?
सुधा काकरिया से फैमिली रिलेशन थे, मेरे फादर जानते थे उनको। और
We had family relation.
काकरिया,
My father used to know her.
या
She was known to my father.
Yes. Don't say yeah or okay.
यस जी। बड़ी पहली बार चढ़ी हूँ ना तो मुझे डर लग रहा है। बात ये है।
At the time of lending the amount, was there any agreement entered with the defendant?
जी, यस।
Can you indicate what were the terms and conditions of the agreement?
उनसे बोला गया था लाइक जो अभी मैंने बताया 3 महीने पहले मैं नोटिस दूंगी। मैंने 25 लाख रुपए मांगे थे, उन्होंने 25 लाख रुपए दिए 15% उस पे ब्याज पे।
Like I said earlier, that she sees the money as 3 months as from my demand. I had given her fees 25 lakhs on 15%
इंटरेस्ट।
Can you indicate whether the parties had taken steps in terms of the agreement as you have stated?
उन्होंने पेपर वेपर साइन किए थे।
आप और उनकी।
जी।
Yes, we had signed some documents.
Apart from it's answer. Apart from signing documents, did you take any steps towards the agreement as was agreed with Sudha Kankariya?
ना उनके सिग्नेचर विग्नेचर लिए थे और उनका वो ब्याज जो आना था ब्याज ब्याज दिया उन्होंने 1 साल।
I had a picture of her criteria, and she had paid interest of for 1 year.
नहीं 1 ईयर 1 साल का है मेरे पास, ऐसे भी है और 2-3 साल दिए थे फिर उन्होंने रोक दिया था।
3 साल का इंटरेस्ट।
हाँ 2-3 साल का, 2 साल का तो है मेरे पास।
Thereafter, she had stopped paying.
जी।
When money was given? When money was given by you?
माय मनी आई थिंक 2014 की 15।
Showing a document
ओके।
shown document appearing at page 1 and 2 of the paper. I'm kindly indicate what this document is about.
ये बैंक का अकाउंट स्टेटमेंट है।
This is an account statement of
एक्सिस बैंक का अकाउंट स्टेटमेंट है ऑफ कौन सा 2014 से 2015 का। 1/4/2014, 31/3/2015।
Whose bank account statement is this?
ये मेरा है।
my bank account.
How have you obtained this document?
जी मैं बैंक गई थी, उनसे मैंने बोला मुझे ये स्टेटमेंट चाहिए, उन्होंने मुझे दिया। मैं उनके साथ बैठी थी, मैंने बोला कि मुझे आपका साइन भी चाहिए, साइन किया, सील किया उन्होंने। सॉरी।
I went to the bank and asked for my statement of account. Thereafter, issued statement of account along with signed.
मेरे मेरे होने के मतलब मैं वहीं थी जब दे
I
रहे थे।
was present when they had
statement.
Whose signature is appearing on this document?
Then take to the outcome.
तो ये बैंक के मैनेजर का,
The signature of bank manager.
उस समय के जो मैनेजर थे, क्योंकि वो बदलते रहते हैं.
What do you have to say about the contents of this document?
जी, इसमें जो उनको पैसे दिए, हाँ,
May I tender this document?
Is it signed?
It's
Original document.
it's not.
Exhibit A.
Shown document appearing at page 3 of the judge's brief of documents. Kindly tell this court what this document is about.
ये कंफर्मेशन ऑफ अकाउंट्स है जो मैंने पैसे दिए थे उसके. इससे 1 अप्रैल 2015 का है.
Confirmation of account.
हाँ.
Which I had to see.
ये सूट जब फाइल किया गया, when the suit was filed, it was in the name of Bhavana Botra.
जी,
Who is Bhavana Botra? Why name is changed?
I changed my name.
Were you residing in Kolkata at that time?
Yes.
Your Lordship was pleased to allow the amendment. It carried out an amendment.
Why there is a Kolkata address?
मैं पहले रहती थी कोलकाता में, मेरी शादी हुई थी, रहती नहीं थी, शादी हुई थी, तो थोड़े दिन के लिए मैं आती जाती रहती थी. और इधर सबसे लाइक मेरा एक्वेंटेंस था, मैं इनको जानती थी, सुधा काकरिया और सबको.
At that time of
काकरिया. भावना.
Alright, may I proceed?
WANA. WANA.
Who had issued this document to you?
देखिए, मुझे सुधा काकरिया की यहाँ से मिला था, मैं रहती थी नहीं, उनके यहाँ से मिला था, उनका साइन और सब है, मुझे मिला.
this was issued by at that time I was not residing in Calcutta.
नहीं, ये हाँ, ये तो
तो रहती नहीं.
आती जाती रहती थी.
I used to visit also.
Shown document appearing at page 4 of the judge's brief of document. What is this document about?
ये भी अकाउंट्स का ही है. कंफर्मेशन ऑफ अकाउंट्स 1 अप्रैल 2016. सुधा काकरिया. जी, मुझे सुधा काकरिया से मिला.
I received this document.
How did you receive these documents?
नहीं, उधर से ही उनके ही आदमी ने लाके दिया था, उनका सिग्नेचर, मेरा सिग्नेचर 2 मिले थे, तो एक वो रखे और एक मेरे को दे दिया।
I received a person from the Kakarya side and documents. He took my signature in one of documents and just another document that is another that is then the document is covered. And copy of that. Well, answer to put. I received from a person. I received a person from Sudha Kakarania's side came to me and person and gave me these documents. He took my signature in one of documents and took it with him and gave the copy of that document that is with me. তোদের উনি সাইন করে একটা ইংরেজি একটা রেখে দিয়েছে
Were these documents prepared in duplicate and one of the copy was handed over to you, whereas the other copy was returned to the defendant?
उनको दिया।
Yes, that is so. Is there any signature appearing on these documents? Are there any signatures
Yeah.
appearing?
ये सुधा काकरिया की तरफ से है और ये मेरा सिग्नेचर है।
In the first document,
on the right hand bottom signature of Sudha Kakarya appears. The right hand bottom signature of Sudha Kakarya appears and the left hand bottom I have
How do you know signature of Sudha Kankaria?
पर मुझे किसी ने लाके दिया तो मुझे लगा उनका ही होगा सिग्नेचर।
I thought this must be her signature since the document was handed over to me by Sudha Kankaria's men.
ओके,
It was not signed in your presence.
नहीं,
Sudha Kankaria did not put signature in my presence in these documents.
my lord, may have tendered this document.
It will be marked, but signature will not be identified. She is not identifying the signatures.
Collectively.
Two documents are there, so collectively B.
Yes, it will be collectively, exhibit B collectively.
Have Sudha Kankaria ever signed, put any signature in your presence?
नहीं
आपके
सर,
सामने कभी साइन किए थे उन्होंने?
सर नहीं।
On documents appearing at pages 7 to 13 of the judge's brief of documents, kindly indicate to this court what these documents are about.
जी ये मेरा अकाउंट है एक्सिस बैंक।
আগের কোশ্চেন যেটা বললাম না, whether signed in your presence, ওটা টু দি কোর্ট করে দেবে।
हाँ, स्टेटमेंट ऑफ अकाउंट, ये स्टेटमेंट ऑफ एक्सिस बैंक का अकाउंट है। 1/4/15 से 2016 तक का।
Whose account, whose bank account? Sorry, may I rephrase, madam? On behalf of whose bank account are these statement of accounts of?
This is a statement of account.
जी.
Can you identify that this is a statement of bank account?
जी.
Whose account? In respect of whose account?
My account.
This is your question.
My.
This is the statement of my account. One Nation, which bank?
Axis Bank.
Axis Bank, which branch?
Axis Bank. Oh, just a minute. Hughes Road branch. Hughes Road,
Mumbai.
Mumbai.
देखिए तो মেবি দেখো স্টেটমেন্ট ব্রাঞ্চটা হচ্ছে হিউজ রোড আর এটার প্রিন্ট আউট হয়তো এখান থেকে নিয়েছে why there is a signature of some person of Fair Street branch?
Sorry.
This is signed by some officer of the bank
जी.
of Fair Street branch. Why it is so?
मुझे समझ में नहीं आया.
ये देखिए सिग्नेचर देखिए. Just see the signature. Some bank official of Fair Street branch signed it.
हाँ जी.
स्ट्रीट ब्रांच का आप बता रहे हैं
जी.
स्ट्रीट ब्रांच के आदमी
हाँ तो पर एक कहीं पे भी होता है बैंक तो दूसरा नहीं कर सकता है क्या? दूसरा बैंक भी तो कर सकता है अगर अपन
दूसरा ब्रांच कर सकता है.
हाँ सॉरी दूसरा ब्रांच कर सकता है अगर अपन
This
स्टेटमेंट
was
मांगे तो.
the printout of the statement of account was taken at Calcutta
जी.
from Fair Street branch of Axis Bank.
Lordship, this was not part of the judge's brief of document.
The judge's brief of document, no, the judge's brief of document contains the same statement, but the stamp was not appearing. My lord, we have obtained a specific copy with the stamp because these were the originals in order to prove it. So that copy I have handed over, my lord. Same copy.
I mean to say, I mean to say, the statement of accounts of my statement of my account maintained in which branch? Hughes Road branch, Mumbai, was taken at Kolkata and certified by Kolkata Fair Street branch official.
This one.
Is it so?
Yeah.
Yes. Yes.
Sorry sir. Yes.
How have you obtained this document?
बैंक में जाके.
I went to the bank and
Are there any signatures appearing on this document?
स्टील्ड और स्टैम्प और उसका सिग्नेचर है मैनेजर का
Yes.
Which manager? Which branch? Explain that.
कोलकाता एक्सिस बैंक हेयर स्ट्रीट ब्रांच
The statement was certified by the manager of Axis Bank, Hay Street branch.
हेयर स्ट्रीट ब्रांच
Anything more today?
My lord, I'll just tender this document.
If any further question is asked, he'll collapse.
She will collapse.
यस
My lord, generally the first students read up everything very prepared. When brought to test, they find it very difficult. It's a similar situation today.
He's all the more scared.
My lord, may I stop here today?
Would you be able to come on 28, 29, 30, 3 days, consecutive days I can fix for you?
दिस मंथ
Yes.
ओके
3 days.
Will you be stable? Will you be staying these 3 days here?
आई विल बी गोइंग टू मुंबई
I know you'll be going to Mumbai. But for continuous stay, can you be able to stay here for continuous 3 days?
ओके सर
Or have you any problem?
नो सर
PW1 is examined in part, examined in chief in part, further examination in chief and cross-examination will be on 28th April, 29th April and 30th April consecutively.
बैन बच जाएगी
8:29. My lord, may the witness be discharged for today.
No,
No,
witness
step
will not be discharged right now. After cross-examination, she will be
down.
discharged.
Sorry, my lord, for now.
Yes, what discharge?
May he step down.
He is still under oath and continue to be under oath.
Grateful.